Today, I want to give you the ultimate guide to DWI in Texas. Hello, everyone. I'm Jeff Hampton with the Hampton Law Firm. Welcome to our YouTube channel, DWI in Texas. We're going to do an extensive, pretty all-encompassing video here today, going over what you need to know about DWI laws in Texas. Okay, now, by the way, if you wait around to the end of this video, I'll also give you a free ebook, The Ultimate Guide to DWI Defense in Texas, okay? Now, DWI, everyone knows that driving while intoxicated is illegal. It's illegal in some form or another in every state in the United States. But when you look at driving while intoxicated, basically in Texas, under Texas law, it is illegal to operate a motor vehicle in a public place while you are intoxicated. Now, let's talk about what all that means. A motor vehicle, what does that mean? Let's define some terms. That's a car, a truck, a motorcycle, quite frankly, anything that has some type of engine that can allow it to operate on a public roadway. Now, what does public place mean? Public place means a street, a highway, or any place, and here's where it's key, any place where the public has substantial access to. So that even means sometimes private parking lots. So there may be areas where you think you might be on private property, but in fact, the law has said if the public has substantial access to it, that can still be deemed a public place, all right? Now, what about intoxicated? What does Texas law define as being intoxicated when it comes to DWI law? Well, intoxication means it's really defined in one of three ways. Now, these are all labeled as or, so only one of them has to be proven, not all of them. Number one, not having the normal use of your mental faculties due to the introduction of alcohol into your body. Number two, not having the normal use of your physical, or I should say lacking the normal use of your physical faculties due to the introduction of alcohol into your body. And then number three, the one example that everyone knows, having a blood alcohol concentration of 0.08 or higher at the time you were driving, okay? So that's the one everybody focuses on. But technically, you can be proven to be intoxicated under either three of those possible explanations under Texas law, those definitions. Now, here's the crazy thing. Did you know that you could get a DWI even if you're below the legal limit? Now, I kind of gave you a hint at that a minute ago. And here's the crazy thing that happens. You would think that the police, after they do that and they test somebody and they find out that they're under 0.08, that they would just let them go. But technically, I have seen police officers and I have seen prosecutors choose to continue to prosecute someone that even though they were under the legal limit at the time they gave their breath or blood test, they did not like the way they looked on the video, so they believed they were still intoxicated, and that individual could still be charged and brought to trial on a DWI when they were under 0.08, okay? So also, here's another one that might surprise you. You technically don't have to be driving, quote unquote, to get a driving while intoxicated case in Texas. I know it sounds crazy, but technically the law says you are not to operate a motor vehicle while intoxicated. Now, I mean, that sounds like some real, lawyer talk there, right? Trying to make a distinction between one or the other. But the Texas Court of Criminal Appeals has made some distinctions when it comes to this. It is possible for you to be operating a motor vehicle without the vehicle actually moving. One example of that is, let's say you're sitting in your car is started, car is in drive, but you're not moving the vehicle, okay? Under certain types of case law, it's out there saying that can be operating a motor vehicle, okay? So also you can get a DWI for driving while intoxicated with using a valid prescription. Many people don't think about this, but it's not just alcohol. You can actually be charged with DWI for having taken a prescription drug. You remember all those, if you get prescriptions where it'll say something, be careful when you operate a vehicle? Well, if you take it thinking you're going to be okay, you may have had no intent to be driving while intoxicated, but if it causes some type of depressant effect on your body and you get pulled over, you can be charged for a DWI for a prescription drug just as easily as a alcohol-based intoxication, all right? And of course, I won't waste any time talking about illegal drugs. Of course, cocaine, heroin, methamphetamine. If you use an illegal drug, you can also be arrested for DWI for the use of illegal drugs while you're operating a motor vehicle. Now, let me go very quickly over the criminal consequences of DWI. If it's a first-time offense, your first-time DWI in Texas is a Class B misdemeanor. The range of punishment is a minimum of 3 up to 180 days in jail and up to a $2,000 fine. Also, sometimes there's court costs associated with the case depending upon how you resolve it. Now, be aware of this too, and I'm going to talk about it later. You need to be aware of the fact that if you do not handle your license revocation issues properly, you could also be talking about some additional expenses related to surcharges or actual suspension of your driver's license, okay? Now, what about a DWI second? A DWI second is a Class A misdemeanor under Texas law. In the range of punishment is a minimum of 30 days up to 1 year in the county jail, up to a $4,000 fine. And once again, if you don't handle your license issues correctly, once you get a second DWI, you could face a driver's license suspension of up to 2 years. Now, a DWI third takes it to a whole nother level. A DWI third is now a felony charge. You're now talking about a third-degree felony punishable by a minimum of 2 years up to 10 years in prison and up to a $10,000 fine. You can also face a driver's license suspension of up to 2 years, okay? Now look, if you get to fourth or fifth DWIs, you get to a fourth DWI and you've already been convicted of DWI, that's a problem because now you could be facing up to 20 years in prison. Things just get more serious from there, okay? So those are a few things to be aware of. By the way, if you end up having a blood alcohol level over 0.15, or if it's your second or more DWI, there's also going to be a requirement as a condition of your bond that you will have to have an ignition interlock device in order to stay free. Now, a lot of times people will call me and say, that doesn't seem fair. I don't get it. Why do I have to have this? Even if it wasn't for alcohol, which is honestly the dumbest thing I've ever heard, why you have to have an ignition interlock device if you were pulled over for using prescription medicine. But that's the law. If it's your second DWI, it doesn't matter. It's an absolute mandatory requirement that you have to have an ignition interlock device on your vehicle, okay? Now, what's the difference between DWI versus DUI? People ask me that all the time. Is it driving while intoxicated or driving under the influence? What's the difference? Well, under states, when you look at other states, sometimes there's not really a big difference. They call everything DUI. But in Texas, if you were under the age of 21, then having any detectable amount of alcohol in your system could result in you being arrested for driving under the influence, or DUI. Now, that is technically a Class C misdemeanor, punishable by up to a $500 fine and no jail time. Here's the problem. If you don't handle it right, you can still end up having a DUI conviction on your record. So many times there's some mandatory requirements in order to get your DUI case either dismissed or deferred so that you could get it expunged from your record. But it's really important to understand that along with that DUI can come also a mandatory driver's license suspension depending upon how you resolve your case. So that's just a little bit of a glimpse. The main difference between a DWI and a DUI is if you're under the legal limit or the drinking age limit, and DWI is if you're over the drinking age limit. Okay, that's really the only difference in Texas. Now, what are some aggravating circumstances? What if it's your first offense, the first time you've ever been arrested for DWI, and now it turns out that your blood alcohol level is over 0.15? Well, it kind of stinks because the Texas legislature put together this arbitrary rule where they say if you're over 0.15, then you must be much worse than someone who's at a 0.149, right? Well, now they're going to charge you with a Class A misdemeanor with a jail sentence punishable by up to 1 year in the county jail and up to a $4,000 fine. And we get right back to that mandatory ignition interlock device that has to be put in your car, okay? Also, what if you have an open container? What if you're pulled over and you have an open container of a little bit of alcohol in there when you get pulled over for a DWI? That actually works as what they call an enhancement to your punishment range. That can actually increase your minimum punishment from 3 days to now a minimum of 6 days up to 180 days in jail. Okay, it's a small difference, but it does matter. All right. Now, a couple other things. What if you start really elevating things? What if you start talking about a DWI with a minor child in the car, someone who's under the age of 15? You're talking about a 15-year-old or under. Well, in this situation, it's important. If you are driving while intoxicated and you are in the process of transporting a passenger who is under the age of 15, under Texas law, this constitutes a state jail felony that is punishable by up to, it's a minimum of 180 days, up to 2 years in prison and up to a $10,000 fine. Also, depending upon the circumstances of how it all played out, if that minor child was in the car, you could also receive a child endangerment charge that could be added to that set of circumstances. So imagine this, what looks like a vanilla DWI. If you've got a kid in the car, you're facing a felony. Things get serious real quick. So the only reason why I tell you that is because, look, here's the reality. If you're driving down the road and you've had something to drink at a restaurant and you got your kids with you, if you get pulled over by a police officer, there is a decent chance if they smell alcohol on your breath, you are going to jail. So it's important to be aware of that whenever you're driving and if you got kids in your car, because you're not talking about a misdemeanor anymore. You're talking about a felony charge, okay? Now, what about intoxication assault? Intoxication assault, if you are driving while intoxicated and as a result of that driving, it causes an accident in which someone is seriously injured. When you talk about a serious injury, you're talking about something that causes a permanent or protracted loss of use of someone's bodily members or organs, like someone's crippled or someone's hurt very badly, they end up in the hospital. That could be a third-degree felony. And a third-degree felony that would be punishable by up to 10 years in prison and up to a $10,000 fine. And so as I mentioned, serious bodily injury has a very specific definition. It must be an injury caused by the driving while intoxicated that causes a serious, literally a protracted or permanent loss of use of your bodily members, your hands, your arms, your feet, whatever, or your organs, like it causes someone to not be able to function in the way that they used to function. That's the definition of a serious bodily injury, all right? So those are important things to be aware of because in that situation, you're facing a felony charge. Now, what about intoxication manslaughter? A DWI that results in the death of another person, if you truly were intoxicated, now you're looking at a second-degree felony punishable by up to 20 years in prison and up to a $10,000 fine. And obviously things get very serious in that situation. You have someone who's no longer alive. You've got the death of someone. You combine that with those circumstances, you're talking about a very serious case. Now, what about prior convictions? Well, if you've had prior felony incidents that resulted in a conviction, the state can actually use those prior convictions and enhance you to whatever you were looking at. They can raise that up at least a level based upon your priors, if you have any, all right? Now, how can an employment affect your life? How can a DWI affect your life? I kind of gave it to you, right? Well, first is employment. One, you can lose your employment. If you take a DWI conviction, you could get fired. In fact, many employers, depending on, let's say you're a truck driver, let's say you're someone who drives for a living, or someone who has a CDL license, there are many people who, when they find out that they're facing a DWI, many employers, unless they're exonerated, will consider terminating them. And here's the thing, in Texas is an employment at will state. That means unless you have an employment agreement in place, your employer can technically terminate you for any reason other than for the federally protected statuses of gender, age, race, religion, or disability. In other words, they can fire you and they can do it legally. So it can have a very profound effect on your employment prospects if you take a conviction for DWI, all right? Now, how do you get arrested? Let's talk about the legalities of how you end up being arrested for DWI. In order for a police officer to pull you over, let's say you're just driving home from a restaurant at night, hung out with some friends, had 3 or 4 drinks. How does a police officer even pull you over? Well, first of all, they are going to have reasonable suspicion to believe that you're breaking the law in some regard. They can't just pull you over for no reason. The law says a mere hunch or just hanging out in a parking lot thinking that everybody leaving a restaurant or bar is drunk, that's not proper. Okay, reasonable suspicion is more than a hunch. It must appear to that police officer that you may have committed a crime of some sort. Now, they're not going to be able to know by just your driving usually that you may have reasonable suspicion for DWI. So what they do is they do something different than that. They look for a traffic violation. If you're speeding, if you failed to use your turn signal in the time frame that you're supposed to when you're going to make a turn. What if you are weaving a little bit in and out of your lane? That's an example of that. What if here's the one that always gets me. I've had many clients, they get pulled over because they didn't stop before the crosswalk. They'll stop in the middle of the crosswalk, and that is technically a traffic violation. So the client's doing everything they're supposed to, except they pulled right over that big white line. And the next thing you know, they're being pulled over. So many times, though, police officers will claim they see a traffic violation, but your experienced and aggressive DWI attorney should make sure they take a look at that video, compare it to the police reports to determine, because we've had many cases where a report will say one thing, and then we take a look at that video and we find out, wait a minute, that's not exactly what it looks like happened here. And if you can create doubt, reasonable doubt regarding the legality of that stop, then it may be possible that the entire DWI would be thrown out through a motion to suppress, okay? So that's one example. Here's how they pull you over. So what about once you get pulled over, they get you out of the car? Well, here's what they're going to do. They're going to ask you to do some field sobriety tests. And understand, what is a field sobriety test? Field sobriety tests are actually promulgated by the National Highway Traffic and Safety Administration as a way for police officers to create probable cause to arrest you for DWI. That's what they're created for. That's the whole purpose. There's 3 main standardized field sobriety tests. The first one is called the horizontal gaze nystagmus, or the HGN test. And many people don't know what the name of it is, but they know it as the pen test. You've seen it before. The police officers moving the pen in front of somebody's face. They're being required to follow it with their eyes as they're looking at the police officer. Well, here's what they're looking for. Nystagmus is the involuntary jerking of the eye. Everybody has it, but it's just usually not obviously seen by just by looking at someone, unless you basically have some type of central nervous system depressant that is taken. That makes it more visible to the naked eye, okay? But here, I just want you to understand, these tests are only as reliable as the police officer administering them. If they do not administer them properly and they do not handle them the right way, I just want you to know up front, they're worthless. So that's one of the things your attorney needs to look into to make sure they're administered properly. All right, now that's the first one. And I'm not even going to get into all these other things because you can have natural nystagmus. There can be other reasons why it might appear that you look like you're intoxicated on this test that have nothing to do with alcohol or drugs, okay? But the first one is horizontal gaze nystagmus. Number 2 is the walk and turn test. Here's what they're going to make you do. They're going to make you stand with your feet together, hands by your side. They're going to ask you to walk heel to toe 9 steps down either a real line, or the one that gets me is the imaginary line that the officer asks you to create in your mind. And they want you to take 9 heel to toe steps and then execute a 3-point turn and walk 9 heel to toe steps back. During this period of time, you're going to be counting out loud each step along the way. Now, if you slip up, if you fall back, or if you just hesitate for a second, every little slip up is going to be seen as a violation. In fact, you can fail the test before you even start the test. Here's the crazy thing. The officer, if you start to take a step before he tells you to go, that's a violation, right? What if you don't stand in the perfect position he wants you to stand in? What if you have to scratch your head, or you reach around to adjust your shoe? That's a violation. You only need 2 clues to fail the test. So I've seen clients do wonderfully on this test, but the officer claims because they didn't start when he wanted them to, that they failed the test. So sometimes these tests are not always set up for success, all right? Then the next test we're going to talk about is the one-leg stand. Here they're going to ask you to put your feet together, hands down by your side, hold 1 foot out 6 inches from where you're at, 6 to 12 inches out from where you're at. And they're going to ask you to look down at your foot and count out loud for 30 seconds. Well, what happens if you start to sway back and forth? That must be because you're drunk. What happens if you put your foot down? That must be because you're drunk, right? Once again, all of these things are going to be used against you to make it appear that you were intoxicated based upon your performance on the test. Now, I want you to understand this. I've already articulated this, but these tests are notoriously faulty. I mean, think about the walk and turn and one-leg stand. They are literally tests that are designed to determine your physical ability. Well, in a test that's involving your physical ability, think about this. What if you don't have very good balance? What if you're not very coordinated? What if your normal is not the police officer's normal? What if he looks at you and says, I think I could have done that. Why didn't you do that? Once again, they're subjective. So there can be many reasons, including test anxiety, being scared to death, why someone might not do well on a test like that. So it's extremely important to recognize that your attorney needs to go through that extensively to determine whether those tests are reliable, okay? Now, let's say you're now arrested. Once you're arrested and you're brought into the police department, they're also going to ask you to give a sample of your breath or blood. If you refuse the breath or blood sample, they can suspend your driver's license for up to 180 days. If you consent to the breath or blood sample, they can actually still, if you're over the legal limit, suspend you for 90 days, okay? But let me just tell you this. Look, when you start talking about trying to make decisions on this sort of thing, it's important that you realize you always have the right to refuse a breath or blood sample. In fact, if there is one that's more reliable or more accurate than the other, it's usually the blood compared to the breath, because the breath test is just a machine. It's an instrument, and it can malfunction. There can be problems with it. It can be unreliable. But I want you to realize, we talk about the consequences if you refuse, but there can be consequences if you agree to the test as well, particularly if it's used against you and the test was not administered properly, and your attorney needs to look into that to make sure the machine was operating like it was supposed to. Now look, you get booked into jail, you can post bond, you'll start to go to court. I'm walking you through this just a little bit. And as you do it, I want you to understand the prosecutor is going to make you a plea bargain. But you need to weigh the consequences of a plea bargain because of the effect that it can have on your life. And that's where it comes down to making sure you're working with an attorney that knows what is fair based upon your set of facts. The prosecution is willing to wait you out and try to intimidate you into taking a plea deal. Your attorney needs to do the extensive work to make sure the case can be proven. You don't have to prove anything. The state has to prove the case beyond a reasonable doubt, and that's where the work needs to be done by your attorney. Now, one of the things that I want to talk to you about is if you did take your case to a trial, please understand this. There's only a couple of ways to get a DWI off your record. Not guilty verdict or a flat-out dismissal. That's really the only ways to do it. So sometimes the best course of action is to take your case to a jury trial and to argue those issues in front of a jury if the prosecutor is not willing to be reasonable, okay? Now, and I won't go into that. Most of you know what they are, but I'm just going to cover, if you've seen what a trial's all about, if you watch TV for the most part, but I'm going to talk to you about a few of your defenses. One could be, number one, you were not operating the vehicle. Okay? If you were sitting in your car, sleeping it off, car is in park, maybe you had your car on and you had your air conditioning on because it was hot in a Texas summer, there's a good argument to a jury you weren't operating the car. You're just sitting there. Okay? That's a good argument. What about the police did not have reasonable suspicion to stop you or probable cause to arrest you? We've covered that already. If that happens, your attorney can file that motion to suppress, and your case may be able to be thrown out. That's defense number two. Then we talk about defense number three. What if your blood test or your breath test was handled improperly or it was defective? We have seen breath test instruments be defective. They were not, there's all these reasons why. They had not been maintained. There's the actual sample, the sample chamber that they used for the breath alcohol volume didn't register correctly, or there was no .02 agreement. There's lots of things I could go into technically with you why it's not always reliable, but these are things that's why you need a very experienced DWI attorney to look over these. Another one, what about the next one, is what if your blood was not handled properly? The blood may not have been handled properly if there's no chain of custody, if the testing wasn't done properly. We've actually seen some cases recently where the actual seal on the blood vial came undone, and as a result of that, what happens on spoilage? A byproduct of spoilage and decay is alcohol. And so as a result of that, you couldn't rely upon that. So these are all things to look at. If they administered poor field sobriety tests, that's another example. These are just a few of the things that we can look at, any attorney that you decide you want to work with, and ultimately you can go to trial. If it's all based upon an officer's word, you may be able to destroy the credibility of that witness by being able to cross-examine that officer on the witness stand. So I say all that to say this: the decision that you make is important, who you hire as your attorney. Listen, your freedom is at stake. Your career potentially is at stake, depending on what you're doing in your life. And certainly your driving privileges are at stake. if you've been arrested for a DWI, you have 15 days from the date of your arrest to request that license hearing. If you miss it, your license will be suspended automatically 40 days after the date of your arrest. Protect your driving privileges as well. So you don't want to take a bad plea deal. You don't want to destroy your life. It's important to make sure that you're doing all that's necessary to cover yourself if you or a loved one have been charged with DWI. I know this was a long video. I wanted to make sure and cover all that I could in the time that I had to give you an overview, an introduction, if you would, into Texas DWI law and what to expect. If you or a loved one are facing a DWI in the North Texas area, don't hesitate to contact the Hampton Law Firm at 817-877-5200. I'd be happy to give you a free consultation, walk through the case facts that you have, and see if we can be of assistance to you. And by the way, I promised you if you waited around to the end of this video, I'd give you a free ebook, The Ultimate DWI Guide in Texas. If you click the link down here below, I'll be happy to send that over to you. I want to thank you for joining us here today. Thanks for being patient with me as we went through this. I hope this was of some value to you. If it was, subscribe to our YouTube channel. We'll send you more great content just like this. Thanks again for joining us. Take care.